also trying to just switch to my other network, which is taking my
Tunaona.
Who is that? Can you guys hear us? Oops. Share screen. It's okay, Julie. I have now managed to share and I'm sharing the screen.
Okay, thank you.
Yeah, so feel free. The floor is yours, you can now proceed.
Okay, thank you. I think someone was saying there is too much echo. I don't know if the echo has reduced.
It was actually me moving from one gadget to another. So I had both accounts. I had opened in two gadgets. So sorry, guys. Let's proceed, Julie.
Okay, thank you so much, Jane. So I think I've already given my introduction, and I think we can proceed now. Next slide. So as Jane is changing the slides, we are going to look at the major discussion points in today's webinar are going to be the key contributors of ADR to HRM practices, which I have already said. And you're going to look at the systemic review of employment and labor cases. In this, we are going to evaluate how, as I have previously stated, that the judiciary and the ways of litigation are being churned out, and we are going to majorly go to now how mediation is being used to solve cases. And we're also going to look at importance of mediation in resolving workplace disputes. So Jane, you can move to the next slide. So the first thing of importance is to try and understand what is alternative dispute resolution. I know everyone has an idea of what alternative dispute resolution is, but it's basically settling disputes out of court, you see? And I think in the past, we used to see how traditional elders used to settle the disputes in small gatherings. That is a form of dispute resolution. So any dispute that is settled out of court is termed as alternative dispute resolution. And it's a voluntary process in which we see that a third party is used to try and keep things neutral. We know that the Kenyan legal system is highly adversarial. And in that, there is no way that parties are going to be friendly to each other, but you're going to see what are some of the benefits of using alternative dispute resolution. It is important to also note that alternative dispute resolution in short form, ADR is enshrined in the Constitution of Kenya, and that is under Article 159(2)(c). So when you'll hear anyone promoting ADR, it is important to also understand that it is provided for in the Constitution. And the various ways of ADR that are provided are, there's reconciliation, mediation, arbitration, and traditional dispute resolution mechanisms. Now, just a pointer, when we talk about traditional dispute resolution mechanisms, they are supposed to be used only to the extent that they are not repugnant to justice and morality. You see, sometimes, for example, you've had cases where maybe a rape case is trying to be mediated, and maybe it is not in the best interest of the victim. Sometimes maybe it involved a child, and it is not in the best interest of the child. So traditional dispute resolution mechanisms are only used to the extent that they promote justice. So you can go to the next slide. So we are going to see the statistics of ADR in Kenya. I think that's the slide that we should be on. You've gone too fast. So as you go back to the statistics of ADR in Kenya, you'll see that in Kenya, generally, people cannot afford litigation. The court process is very expensive, and sometimes that's why some people would say justice is to the highest bidder. As an advocate, I would agree that indeed the court process is not very affordable to all Kenyans, and that's why you'll see most Kenyans are actually finding justice outside the formal court system. And it is working for most people because they actually are satisfied with the outcome. And as I've said, mediation is one of the alternative dispute resolution mechanisms. And we've seen how the Chief Justice Emeritus, David Maraga, had launched the Court Annex Mediation System. And the Court Annex Mediation System has helped to a large extent reduce the backlog of cases, which I was earlier talking about. And we've seen a 40% reduction of cases since the implementation of ADR mechanisms in the courts. So we see that indeed ADR as a method of resolving disputes is widely accepted in Kenya, and it is a form of dispute resolution that aids in promoting the relationships of the parties, and you're going to see other advantages of ADR. You can move to the next slide. So I had earlier mentioned that the theme for the HR month this July of 2021 is green HRM practices. Now, it is important to understand what do we mean by green HRM, because I've also seen in the course of my research that there's also green finance. So what does it mean to have green HRM practices in an organization? Now, green HRM practices are the practices that maintain the sustainability of the organization. They're actually aimed at expanding the role of the HR to support the organization in pursuit of sustainability. You see, so any policy that is going to emanate from a HR manager should be aimed at supporting the organization and should show that it's actually promoting sustainable use of resources and that they preserve the natural environment. You know, and these green HR initiatives are from things like staffing, performance management, to training and development and employment relations. So we see green HRM basically, in short, is just policies and practices that aim to make the organization more sustainable and even the business more sustainable. Now, you can go to the next slide, which you're going to now see what is the nexus between alternative dispute resolution and green HR. If you remember earlier, I had said that the theme or the topic that you're covering today is alternative dispute resolution at the workplace. So how is alternative dispute resolution connecting to green HR? We are seeing that it is evident that the ADR mechanisms reduce the burden or cost of litigation to all HR managers and also to all organizations. This is because, you see, when you use alternative dispute resolution mechanisms, you can settle these disputes internally before they escalate to a litigation process. You see, so the amount of resources that an organization will incur in resolving disputes will largely decrease. I know you've heard of even employees for example, let me say, in the court system, there's something called class suits. So where a group of people, let's say a group of employees, decide to now sue an organization, you see that will really cost the organization so much. So we are saying that alternative dispute resolution mechanisms is a form of green HR policies, is a form of sustainable HR practices Therefore, we are going to, as an advocate and also as a mediator, I'll encourage HR professionals to try and see how they can incorporate alternative dispute resolution mechanisms into the HR policies of the company, so that before decisions escalate to a point where it is just litigation and there's no turning back, and then the organization incurs too much costs paying damages, compensation, and in cases where it was a class suit, many people are being compensated. We are saying use alternative dispute resolution mechanisms. We can proceed to the next slide. So the conclusion on my first theme, as I have said, is that alternative dispute resolution is indeed a key contributor to sustainable human resource management practices. I could go on and on to emphasize on that, but I would like to just encourage us to try and not always rush to court to always solve issues, because we've seen the litigation process is indeed tedious. Sometimes you enter court today, you of course you filed your case, then you're told the next mention is in 3 months, but your grievances are still ongoing, they're not still being addressed yet. You could just sit down with a mediator, a professional mediator, and try and resolve the dispute, and everyone to have their way and at the end of the day. So as we are now going through the HR month and it's coming to a conclusion, we are seeing that alternative dispute resolution mechanisms should be embraced in the business sector, in organizations, because they promote sustainability of the organization and they reduce wastage of resources on things actually that could be solved at an internal level. I don't know if there are any comments on this first theme before we proceed, or maybe Jane, you could say something.
I think it's very good that you're trying the theme of the month with what we're discussing today. Let me just stop the share a bit. But I would still suggest we keep the questions to the end, or maybe for the next theme, because I feel like this was a big introduction to what you have for us today. Is that the case, Julie?
Yeah, that is okay.
Yeah, so I would say we proceed and go to the next theme, but I hope we're able to connect what we mean by green HR, green finance, everything going green, and what we can do as HR people to ensure that we remain sustainable in the things that we do as HR. So I'm going to just share your screens again, and then we can go to the next theme. If you have any questions, keep them coming in the chat, and Julie, our guest speaker today, will be able to respond to all your questions. So Julie, I'm going back to your slides.
Thank you, Jane.
Okay. There we are. Is that okay, Julie? Julie? Is it me or Julie? I can't hear you guys. Julie's frozen. So just wait for Julie to come back. I think her net has issues. I don't know. Are you back, Julie?
I think she's still frozen, but I'm glad that we are at 315 members. So unfortunately, even me, I'm having issues. My video is not working on this end. Mm-hmm. So Julie dropped out. Let's see. So what we've just covered, and it's interesting for me as the executive director of the Institute and as a representative of the members in the Institute, how one thing links to the other. Because remember, the theme for the month was the Going Green business strategies, HR strategies for business success. Because she talked about the amount of time we spend in the courts. And that I can easily link it to our wellness. When you have a case coming up, the amount of resources that go to in terms of even your intellectual capacity, the resources from the organizations you represent, preparing for it. So a lot of wastage can be saved and salvaged if we now embark on the ADR and it's covered through our constitution and it's an option rather than even how we advise the management. And I must say here, as HRs, professionals, and as we practice this great profession, let us be mindful how we handle people. And let's also be mindful how we handle ourselves, because a lot of mental health issues arise from such cases. So those are some of my takeaways from here, Jen. And I am excited that we are actually having these conversations and seeing as HRs, how can we reduce the burden on us and focus our energy somewhere else as we seek the alternative dispute resolution, or even preventing it in the first place before we arrive at that, which is outside the courts. And lawyers are now not only lawyers, but they're also training as mediators, as we've seen on Julie's profile. Asante sana. Jen, back to you.
Thank you, Koresha. Thank you even for gracing this particular event for us. So as we wait for Julie, I don't know how many of us have tried to actually have anything to do with ADR, because, and I've seen a question here, someone saying if we can put it in the contracts. Actually, most contracts have that. If you look at most contracts, hoping your contract has that, you'll find that at that point of termination and dispute resolution, they say, if for any reason we cannot blah, 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 this particular contract, it will be referred to an ADR tribunal. And it's always important to have that way out, so that in case of anything, in case you're not able to sort issues with the employees, then as a first option, they don't go to court. As a first option, they have a place they can go and you sit and talk and resolve matters outside court. And one thing that I quote when Julie was speaking was when she said, when you have been sued by a group of employees, you can imagine how expensive that would be for you to be sued by a group of employees. So that's very, 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 very key to note. And to just, even if you don't have that currently, to start thinking about it and seeing, and even educating your employees to know that if things ever don't work, if you have any dispute that you cannot resolve internally, there's always an option, and we have that as an organization. So one of the takeaways that I would wish that to take away from today's training is actually that ADR is a function that can rest internally with HR departments. Julie, are you back? Is Julie back? Let me see.
I've just spoken to Julie. She's having technological issues, which she will sort in the next 2 minutes.
Okay.
Maybe at this Gancha, I'm glad someone said we have ADR in the HR manual, and that's the way to go. Because remember, when you're forming these policies as advisories, you ensure that you're consulting all the instruments that are available within the country, from Employment Act all the way to the Constitution. Thank you. Julie is back.
Super. Julie, welcome back. Sorry about that. It happens most of the times.
Yeah, thank you.
Let me just continue from where we were. Was that where we were? Legal framework?
Yes.
Okay, super. We'll come back and take it
Yeah,
up.
I think the previous slide. The previous slide.
Systemic review. That's okay.
Yeah, so I was talking about the systemic review of the employment and labor cases. As my apologies again for the short interruptions. So when you're looking at the systemic review, we have to understand where we have come from in terms of labor laws and where we are going to, okay? So if we talk about the systemic review, that's previously, labor laws were set up by the colonial government and were being used to adjudicate on employment scheme. Their major sources of law were from their countries. We know Kenya borrows heavily from England, and these cases are mostly, this laws, were mostly used to regulate the labor sector in terms of the people who are now assisting to build the economy at that time, who are majorly Africans, okay? So because of now that history that we had to change these labor laws to fit the Kenyan situation. Of course, we see that even when we use or when we borrow a system of law or a type of legislation, ensure that it is particularly fits the Kenyan situation. For example, we know the Constitution of Kenya was borrowed heavily from the Constitution of South, particularly fitting the Kenyan situation. So there was the labor law reform agenda, and this task force was mainly looking at how to make these laws suit the Kenyan situation. And one of the main outcomes was, of course, trying to ensure that the different acts are harmonized and that they are friendly and comprehensive, fit and benefit the people of Kenya. Okay, so we see that indeed there was need to reform the laws, and therefore there was that task force set up, which was within the International Labour Organization project, and it was used to actually bring certain changes to the labor sector. So we are going to look at now, has this or have this changes brought about the desired effect? We still see that employers are still repelled by the expense court decisions. We see now, of course, there are various court decisions, and of course, if an employer has not followed the correct procedure that someone is supposed to be taken through while termination, of course, the court, in its major role to uphold justice to all, has to ensure that it has ruled as per the legislation. So we see employers are still not satisfied, with the decisions that are emanating. And that's why we are seeing many employers are now including binding ADR clauses as well as class action waivers in the employment agreements. Okay, so I've said sustainable HRM practices are trying to look at how we can reduce resources from being wasted because of disputes arising within the workplace. So one of the ways as a HR manager is to include a binding ADR clause. For example, we see in some contracts of employment, it is stated that before someone seeks litigation, they have to go through mediation for a certain number of days. They have to maybe go through arbitration or any other form of dispute resolution, including conciliation. So if it is binding as an ADR mechanism, then an employee cannot be able to go to court without going through the ADR mechanisms which are provided for in that organization and which the employees agreed to at the time of entering into the contract, okay? Then we're talking about class action waivers. I've told you before that some of the decisions from the court, especially maybe if a group of people were suing, of course, show that the people will get compensation as that class suit, as that group of people. So it is important to also appreciate the fact that industrial justice system would be slowed down if all the parties went seeking for support from the civil courts. You see, that's why we are continuously stating that alternative dispute resolution mechanisms are the best forms of dispute resolution. You could proceed. So now we were looking at the legal framework for labor cases in Kenya. You know, when we talk about the systemic review of labor and employment cases, we cannot fail to look at the legal framework, because the legal framework guides us to understand how are cases solved in relation to employment, in Kenya. Okay, and we know our supreme law of the land, which is the Constitution of Kenya. In Article 41 talks about labor relations. It generally provides for the rights of the employee, what an employer should provide generally. And also Article 30 talks about freedom from slavery, servitude, and forced labor. Okay, forced labor, of course, it is a sensitive topic. Anyone can give the interpretation on what amounts to forced labor, but we see the Constitution of Kenya expressly prohibits forced labor. Then we have, of course, the main parent act that relates to employment issues in Kenya, which is the Employment Act of 2007. It talks about the contract of service. It talks about the various rights of the employee, how to go about disputes. And we also see the Labor Relations Act, which is now basically focusing on trade unions, how trade unions are formed. We are looking at the Labor Institutions Act. We are looking at the Occupational Safety and Health Act. You know, that the various health standards that should be adhered to at the place of work. And you've seen, of course, many people actually sue on the basis of Occupational Safety and Health Act. So it's important for employers to try and always ensure that the environment in which the employees are actually conducting their duties is safe for it. The environment in which the employees are conducting their work is safe for habitation. Then we have the Workers' Injury and Benefit Act. We have the Employment and Labor Relations Court Act. We know due to the promulgation of the Constitution of Kenya 2010, we had two courts that have been instituted that have the status of the High Court, which are the Employment and Labor Relations Court and the Environment and Land Matters Court. So we then have the International Labor Conventions, which have been ratified by Kenya. We also understand that if an international convention is ratified by Kenya, it forms part of the law of Kenya. That is by virtue of Article 25 and 26 of the Constitution. And it is important to note that also Kenya has ratified 50 of the International Labour Organization conventions. So this is the basic legal framework for labor cases in Kenya. If any matter is to be adjudicated upon right now in Kenya, you know, the judge or the magistrate or the judicial officer will actually look at the provisions of the aforesaid act and rule according to the law. So that's why we usually say justice is usually administered as per what the law provides. You know, you cannot go outside of what the law provides. Sometimes it might be unfair or it might seem to not favor a certain party, but now as a HR professional, you should understand then what are the ways in which you can actually prevent such kind of, maybe let me say, harsh litigation processes and incorporate other dispute resolution mechanisms. Okay, you can proceed. Next slide. Now, as we look at, okay, you can go to the previous one. Yes, ADR provisions for employment cases. As we look at now employment cases, we have talked about the legal framework. So how or which are the ADR provisions for employment cases? We see, for example, Section 41. This is a very controversial section, you know, that says that an employee is to be dismissed. If the employee is to be dismissed, should be given a fair hearing. You know, most of the employers really sometimes don't adhere to, let me say, the fair hearing principle. And, you know, one of the things to understand when a matter like this goes before court, the court not only looks at the substance of the matter, but also procedural fairness is important. you see? So you cannot just dismiss someone without hearing them out their side of the story, okay? So this fair hearing can be implicitly or mean mediation, you see? So if both parties are brought to the table, you know, the aggrieved party says his or her side of the story, the employer says his or her side, you see, there'll be a better way of resolving a dispute rather than an employer summarily dismissing someone without giving them fair hearing. So I hope the HR professionals are noting that actually you should ensure that one or before an employee is dismissed. And these are some of the common cases at the Employment and Labor Relations Court. Before an employee is dismissed, just use the due process. Due process entails fair hearing, you know, and that will save the organization a lot of costs as regards to compensation and awards of damages, because for sure I can tell you as an advocate, such kind of cases when you just find an organization did not adhere to the laid down procedure, even if an employee is at fault, but there should be a stipulated procedure, okay? So section 59A and to 59D also of the civil procedure talks about mediation and how the court has power to refer disputes to the mediation, okay? We've seen, especially right now in family cases, most of them are screened for mediation, but also we'll see that also the Employment and Labor Relations Court, they are trying to introduce mediation, okay? So we'll see how some certain employment cases are being mediated. Also, if you look at section 73 to 75 of the Labor Relations Act, we are seeing that trade disputes should first be solved by conciliation, okay? You've seen how there are various trade unions, of course, the popular one in Kenya being COTU, and we are saying conciliation is the action of mediating between two disputing people or groups. We've seen how, for example, when the doctors are up in arms, you see, people are quickly trying to mediate and bring to the table the doctors before the matter is settled in court. We've seen also the same case for the teachers, the lecturers. So trade disputes are first solved by conciliation. And then also, if you look at section 47 of the Employment Act, we are seeing the role of labor officers to facilitate parties to arrive at a voluntary settlement. So this is also a voluntary process where you can decide to involve a labor officer who can help to facilitate the parties so that they can reach a settlement that is amicable. Also, if you look at the Labor Institutions Act, and as read together with the Industrial Court Procedure Rules, the court encourages the use of diplomatic means. You see, it is now evident that we are moving from an adversarial way of handling matters to a conciliatory way of handling matters. We are clearly seeing that all the efforts of the judiciary right now is to try to ensure that backlog of cases are reduced and that people actually embrace alternative dispute resolution mechanisms, because I can tell you for sure, as an advocate, not all cases should actually end up in court. Some disputes can be solved internally, but of course, as I'm going to show you the importance of mediation at the workplace, you'll understand that sometimes as the HR manager, it will not be prudent or it will be, let me say, biased for you to be the mediator in a certain case. It will be rather better for you to bring a neutral person who can be able to try and balance the interest, because the neutral person has no stake. So these are the certain ADR provisions for employment cases. Okay, you can move forward. So I just decided to use 2 cases so that I don't bombard you with a lot of legal jargon. I know we are not all advocates, so I just decided to use 2 cases to try and demonstrate the role of alternative dispute resolution in resolving of employment cases. So in this case, James Heather Hayes versus AMREF, it is a 2014 case. We see AMREF was being sued, and the judge in this case said that it is not lost to all that ADR is a preferred and fashionable kid on the block in dispute resolution, Article 159 and Section 15 of the Constitution, in Article 159 of the Constitution and Section 15 of the Employment Act clearly indicate this position. This provides for resolution of disputes through ADR. So clearly the court is saying that ADR should be put to the table. Okay, and that's what I've said previously, not all matters should reach to court. So as a HR manager or a HR professional, you should try and evaluate really, is this pathway or the path that a dispute is going the right way for the organization, yet it could be solved internally. You know, you can just call an independent professional mediator to help you in resolving that dispute. So then we see there's this other case of Geoffrey Mudinja Kabiru and 2 others versus Samuel Munga. We see the Court of Appeal said that where a statute provides for ADR mechanisms, the court and that mechanism precedes the court. The mechanism must be exhausted before invoking the jurisdiction of the court. I think we have had this, especially in commercial disputes, where maybe you signed a contract and of course, there was a dispute resolution clause which was clearly stating that before someone goes to court, they should exhaust the alternative dispute resolution mechanism, either being mediation or arbitration. So it is important to note that as a HR professional, you should also get advice, especially from an advocate, you know, to understand does the dispute within which this act falls encourage actually internal dispute resolution. So if it does, then you will actually be at the forefront channeling from the internal dispute resolution, so that even if the employee wants to take the matter to court, you are actually let me say, protected under the act that indeed the matter should be solved internally. And I've also said in the employment for contracts, you can also expressly provide that matters should go through mediation, you know, before the matter goes to litigation. So we'll see, are all instances or can all cases be mediated, okay? Or are all matters supposed to go straight to the courts? Then, because we are talking about the systemic review of employment and labor cases in Kenya, we are going to see the success of mediation in modern litigation. You know, we are, as I have been saying before, we are seeing the judicial system or the practice moving from adversarial to conciliatory. So the courts are saying, you know, try and settle it out of court. And we are going to see whether this mediation actually is gaining popularity, sorry. And I can say for sure it is, because as I've said, there's the pilot program in 2016, which occurred for the court annex mediation process. But then also the Chief Justice Emeritus, David Maraga, launched a certain mediation settlement week in 2017. And in that mediation settlement week, we saw cases even from the Employment and Labor Relations Court being subjected to mediation. So indeed, mediation is part of modern litigation. You see, even you've seen succession matters currently being subjected to mediation. There's one I have been handling. So mediation is part and parcel of modern litigation, okay? And mediation can be used to solve any kind of dispute. And as a HR, it's not prudent for you to let a dispute escalate to a lawsuit and then it's sent to a judge. And that's why I'm saying there's pre-lawsuit mediation, and it's becoming more accepted as a sensible way of resolving disputes before it turns to litigation. So we are seeing mediation is successful. You know, once especially for court annex mediation, once you've been assigned the mediator, we know there are judiciary accredited mediators. You know, the mediator helps you reach an amicable solution. It is adopted in court and it is binding. Okay, so mediation is successful and it is part of modern litigation. And we are seeing that now increasingly more and more cases are being subjected to litigation. We've talked about family cases. We are seeing children. We are children cases, land cases, succession cases, and even some types of civil cases. So mediation is successful in modern litigation. You can proceed. So the conclusion on theme 2 is that there's need indeed to reduce the backlog of employment and labor-related cases in Kenya. You've seen the statistics that when mediation was introduced as a way of resolving disputes, more than 40% of cases were dispensed of. This reduced greatly the backlog of cases. Okay, so we are seeing employment cases now being handled through mediation, through arbitration, through other forms of dispute resolution as compared to litigation. And then there's a paradigm shift in the resolution of employment-related disputes. Of course, we understand that everyone likes taking each other to court. We believe that the judiciary will uphold the rights. But again, sometimes we see the time constraints that the judicial officer work under, and of course, your justice may be delayed. So as an employee or an employer or a HR professional, the best way when you have a dispute is to say, let us sit down and talk. If we cannot talk, let us bring an impartial arbiter to try and help us solve the issues that are at hand. That is the conclusion on theme 2. Over to you, Jane. I've been seeing questions streaming in.
I've seen that too, but I would recommend you just go to the end in the so that you control more time better, because you might go to the questions and then it goes up to the end. So I would rather we cover as all that you had prepared for us today, and then after that, I'm sure we'll have enough time to answer all the questions. So we shall proceed.
Jane.
Thank you.
I stand guided by you. Thank you.
Okay. There we go. No, it's refusing to go. There we are, theme 3.
Yes. So now we've seen how ADR is a sustainable HR practice. We've seen this systemic review of employment and labor cases, where cases are moving from litigation to mediation, and actually the courts are at the forefront of championing for mediation at the workplace. So now we are going to go to the previous slide so that we can talk about the importance of mediation at the workplace before we just talk about generally mediation at the workplace. You can go to the previous slide.
Okay, that's okay. I don't know why we're not moving.
Okay, you've gone to the conclusion on theme 3. It has gone far.
Sorry, there we are.
Yeah, it is this one. Thank you. So we are saying, what is workplace mediation? Before we learn about its importance, what is workplace mediation? Workplace mediation is a voluntary and confidential process that can be used to attempt to resolve workplace conflict. So we are saying it is voluntary. But as I have said, if you put it as a clause in the employment contract, it can actually be mandatory, okay? But of course, we can see that sometimes mediation will not work, and you're going to see, of course, it's in extreme circumstances, but it is voluntary and confidential. And you've seen that mediation, or rather, I could define mediation as a process in which you use an impartial and independent person, professional mediator, that is, to help you reach an amicable solution. So the mediator will not propose the solution for you. It is the two parties who are in conflict that will come up with a suitable solution for the dispute that they are having at that time. So mediation is carried out by a trained neutral mediator. Okay, as I've said, he works with you and helps you reach the intended solution. So the mediator helps you understand the issues and clarifies to you, because sometimes the warring parties or the parties who are at loggerheads may not be able to understand what are the real issues, because maybe, for example, I can say, having attended a family-related mediation, emotions are flying high, okay? And everyone wants their points of view to be upheld. Or even in a workplace mediation, the employee feels very aggrieved. The HR manager, of course, wants to act in the best interest of the company. So how can we be able to bring these two parties to actually sit down, okay, and be able to understand what are the real issues? You see, sometimes the issues maybe are personal. They are not even work-related. We know people can just not, or sometimes, let me say, some people may find a fault with you and it is not work-related, okay? So the mediator will come and see what are the real issues, you know, and it will help the parties be able to reach an amicable solution. So workplace mediation is popular. As I've said, we are going green HR. We should adopt this, and many organizations are adopting it as a way of resolving disputes, because organizations are in business, okay? And if a HR manager, you are not helping the organization reach its goals by using sustainable means, then you can be said to not have actually or rather performed your role in the best way possible. So workplace mediation is being used, and it's important so that we avoid matters escalating to courts. You can go to the next slide.
I don't know, it's not moving. Just give it some time.
Okay, so in the next slide, we're just talking about mediation in resolving workplace disputes. So previously, we've seen human resource professionals mediating at the workplace. We applaud you. You know, we appreciate the work that you've done. And I know maybe you're not recognized as much, and you should be given recognition, because maybe if it were not for you, the company would have incurred
Let's give Julie a minute.
HR managers are okay for that, ways to be able to be more efficient in training. Work. So we are seeing the HR managers or professionals are trying to actually seek mediation training so that they can be efficient in the mediation. But now, as I've said, sometimes you cannot mediate as a HR manager because you are not impartial. You know, you're acting for the interests of the organization. So that's why in some cases, you are supposed to call an independent professional mediator to try and help you mediate that case. This is because if you bring, or you as the HR person act as a mediator, your biasness might be apparent, you know, and maybe an employee or the party would feel that you won't be neutral, or you won't be able to uphold confidentiality, okay? So this neutrality and confidentiality are very important to access successful mediation. So that's why you're saying, as a HR personnel, as a HR manager, it is important that you bring an impartial arbiter to the organization. so that the arbiter can help you reach the desired goal. Okay. So, and I was saying there are some scenarios where mediation will not be appropriate. For example, when there is imminent danger to an individual, if a party or an employee feels that there is imminent physical danger, of course, it will be difficult to actually want to mediate on such a process, because they will ensure that the mediation fails. So we can see actually that mediation is suitable in most employment, most workplace-related disputes, but where the matters escalated to the point that there is perceived or imminent danger to a person's life. And we've seen, of course, people die in the course of duty, and it involved actually an employee who was plotting on another employee, or whichever way it was within the organization. So, of course, when it involves someone's life, it is difficult to mediate on such an issue, okay? So that is the, let me say, most extreme circumstance in which mediation cannot occur at the workplace. So we can move to the next slide. The next slide is to talk about the instances where mediation occurs at the workplace. I don't know, Jen, if you're able to be there. Thank you. So the situations where mediation might be applied, I've said mediation can apply to most disputes, but which are the situations that mediation apply? So, for example, where there is perceived bullying, there are some people who are generally high conflict people, or people whose personalities actually just clash with other employees, or people who generally do not have, let me say, kind words, or see themselves as better. So if there is some sort of type of conflict that would be termed as bullying, then as a HR personnel, you can try to mediate, okay? Then there is pay or contractual disputes. Of course, this is very common actually at the Employment and Labor Relations Court. You see people are actually suing on matters which were terminated, which were not actually terminated as per the contract, or pays which were not given or upheld as per the contract. In my opinion, actually, if the HR personnel or HR manager is able to sit down and be honest. You see, actually during this COVID, we've seen a lot of employees actually lose their jobs, and there have been a lot of let me say, disputes relating to employment. Now, this is because sometimes the organization has not been forthright in what the status of the organization is. So, if you do not communicate to employees that indeed there is a financial crisis, and maybe that's why we are not able to fulfill our contractual obligations, then the employee, of course, considering that a contract is binding and legally enforceable, will of course sue the organization based on the contractual terms that you had entered in. So I encourage HR professionals to try and mediate such issues in the internal level. If you can't talk to the employee or maybe the person who's aggrieved, bring an impartial mediator to try and help understand what are the real issues at stake. Then mediation can also be used when providing an alternative to formal disciplinary procedures. We know sometimes the disciplinary procedures in HR manuals may be strict, may be harsh, and may not even aim to retain the relationship that was there before. So you can actually, maybe let me say now this is an advice, or you can take it. You can actually provide for mediation as a form of disciplinary procedure, so as to understand why a certain employee behave in a certain way and what should be done moving forward. Also seeing after you've gone through a formal disciplinary procedure or process, you'll require, let me say, mediation or any other form of reconciliation to rebuild the working relationship. We know how disciplinary processes can really, really flare up emotions and create a rift between the employer and the employee. So after a formal disciplinary process, you can put or you can set up a mediation meeting to be able to reconcile and rebuild a working relationship. Also, mediation can be used to help colleagues to form effective working relationships. As I've said, we have some people who are high conflict people, and they usually like, warring with everyone. So you can organize for a mediation training or a mediation talk or a sort of bonding session for the employees, but let me say mediation per se, where colleagues are able to form working relationships. And another situation where mediation can be applied is sexual harassment complaints, though I'll be very expressed with this, that where the matter cannot be mediated, of course, it will be litigated, especially where the harassment has escalated to certain levels, for example, threat of someone's life, and where someone has been violated personally in a certain way, then of course, most of the time, those cases usually end up in litigation. And it's a real issue because sometimes, it is difficult to prove sexual harassment because there is the offender and the victim, and it's only the victim who actually maybe saw the offender harassing him or her. So sexual harassment complaints should be treated with the seriousness that they deserve, and where possible be mediated, and maybe the party aggrieved or the party or who is orchestrating the offense should try to be counseled to live amicably with the fellow employees. Then we have termination of employees. As I've said, during the COVID period, you've seen massive terminations around the world, and it has been very tough for people who are relying on sources of, who their main source of income was from employment, and if these matters could be mediated, we could avoid the many cases we are seeing in court. So we are saying green HR, alternative dispute resolution. So the major way to try and resolve disputes is mediation. And also when an employee is deteriorating in performance, okay, you can opt for mediation and try to see how best to be able to handle the issue before it escalates. Can go to the next slide. So what are the certain outcomes? The outcomes, you can go back to the outcomes. What outcomes can you expect from workplace mediation? One thing I can tell you as an advocate and also as a certified professional mediator, the same way we say in court, you can bring your best foot forward, and sometimes the case might not go as you had precedented. It's the same case in mediation, especially maybe if a party is really not had not really subscribed to the idea of mediation, so the mediation might actually fail. So the most important thing before you begin mediation is for it to be mutually agreed that this is the way we are going to resolve the conflict. And now as the HR professional or the HR manager, because you're the one who is upholding the interests of the organization as regards to human resources, you should be the first one to make the step to approach the employee, to approach the person who's aggrieved, so that the mediation occurs, and then there's a good working relationship, and the relationship is restored. And everyone will have had a chance to be heard. If you've heard about the natural justice principles, you've seen in the courts that most matters do not proceed until a party has been heard. And that's why I say in Section 41 of the Employment Act, we are saying before you dismiss someone from work or from employment, hear them out, give them the fair hearing, okay? So mediation is still dependent on the willingness and the openness of the parties, as I've said, because if parties are not willing and are not open, the dispute will not be resolved, okay? So if an agreement is reached through a mediation process, then it is binding and can be drawn up. The agreement can be drawn up for both parties to enter into it. So mediation is a process that works. We have seen it work for people before. The issue is, are the parties willing and open? Okay, and as the HR professional or manager, you should be at the forefront of trying to resolve this dispute in the best way that you think is amicable, of course, one being mediation. So we can go to the next slide, which now shows us the differences between mediation and litigation. I am an advocate, I am a certified mediator. So in this differences, we are going to see which one will best suit an organization. The theme has been green HR, and in my opinion, I would advocate for mediation, but let us look at the different components of mediation and litigation. Mediation usually occurs by a lawyer who's a national mediator, but these days you also have trained mediators, certified mediators who are not actually advocates or lawyers. So it is just conducted by mediator. But in litigation, of course, each party retains a lawyer. We know the Constitution in the Bill of Rights provides in Article 49, rights of arrested persons, you have the right to have an advocate and proper representation in court. So each party will have their lawyer, okay? So mediation is peaceful and amicable. There is no throwing of stones, you know, but in litigation, we are here to see who's the best winner, you know? And that's why you see sometimes in legal practice, it's called sharp practice. Some advocates actually use dubious means to be able to win their cases. And I think that's why sometimes there's the notion that all lawyers are liars, but that can be challenged. But I can say that litigation, honestly, it is too adversarial, especially if you want to maintain the relationships, it won't be the best way to go. Then in mediation, all information remains confidential. That is because it is only the parties who are involved actually are the ones who are brought to the table to talk about the real issues at hand. But we see litigation, information is submitted to court and becomes part of the public record. So we are seeing in litigation, actually, you know, everyone is brought to the attention of your matter. We've seen even how sometimes divorce matters also have been in the public limelight. If they were actually mediated, and let's say, of course, people have seen that they couldn't stay together, but you agreed that let us, you know, agree on certain things, it could be easier. So mediation keeps information confidential. And if you've noted as HR professionals, you'll see that there are certain organizations which you'll never see them being sued. You should ask yourself why. Because maybe they have working internal dispute resolution mechanisms and they want to protect the name of the company zealously. So if you're looking for ways to also uphold the reputation of your company in the various sector that you are in, you know, it is not good to always see, for example, let's say my firm being sued, my law firm being sued by employees, maybe for inadequate pay or any other thing. Of course, your reputation across board is ruined. So the other feature of mediation is that the parties are able to communicate and brainstorm in order to formulate creative solutions. Because we are seeing in mediation, it is not the mediator who actually gives you the solution. As parties, we give you the as parties, you know the issues that are actually at hand, then you agree, okay, this is the best way forward. Each party gives their position and we say this is the best way forward. But in litigation, lawyers and judges make decisions for the parties. Obviously, the study of law, like what I went through till where I am, took me 7 years. You see, so if I'm given that work and when a client comes in, I give my independent advice as the advocate, and the judge also gives their independent judgment on the matters at hand. So the lawyers and the judges, most of the time in litigation, make decisions for the parties. And sometimes it is not the best decision for the parties, but we give you what the law stipulates. But in mediation, as the parties, you say, okay, this is what is happening. Let us sit down, let us talk. In mediation, the parties decide how long it will take. Because sometimes the problem is a very simple one, which does not need to go to court. So you just sit as the parties who have the dispute, and even within a day, a mediation can take a day and everyone is happy, everyone has gone home. But we know court proceedings, years and years of lengthy negotiations through the corridors of the court. This is tiresome, it is burdensome. Your rights still are being trampled upon as the aggrieved party, as the organization. You're incurring costs, sending your advocates retained always to court to attend to the matter. For sure, Green HR, we will go with mediation. Then you're saying mediation preserves relationships. That is very evident because you wouldn't have thrown stones at each other, but litigation destroys relationships due to the adversarial process. Everyone tries to outsmart each other in court. Every advocate wants to be seen as the best advocate, okay? So you always use the best means, because as an advocate, your duty is to your client and to uphold the interests of your client. So of course, you wouldn't be actually trying to understand the employer or the organization. Therefore, the relationship between the employee and the employer will be severely affected. Then mediation is less formal. This is because you actually don't go through the rigorous court processes of filing documents, entering appearance, giving oral presentations, as we have seen in courts. For sure, it is less formal. And litigation, of course, we know that every case has to be handled according to laid down procedures. That's why we see there are procedures for matters at the Employment and Labor Court, there are procedures for matters at the Environment and Land Court, and so on and so forth. So mediation is more relaxed, we just set a date and a schedule to try and reach an amicable solution. Then in mediation, there is greater compliance. Why is there greater compliance? This is because the parties have neutrally reached an amicable solution by themselves. So they'll tend to agree on what both the aggrieved party and the other party are settled on. But if you look at litigation, compliance is not guaranteed. And I can tell you for sure, there is a contempt of court matter I handled in which I won. And it was, let me say, it was not an employment matter, but it was a land matter, okay? The court has given certain directions that the party at that stage should not interfere with the piece of land pending the Court of Appeal process. But then, of course, we see not everyone adheres to court processes. So I would encourage still mediation, because most parties tend to comply when they have been involved together to be able to reach an amicable solution. We can proceed. So the conclusion on this third theme, the importance of mediation at the workplace. I know dealing with disputes at the workplace is not an easy matter, but the early intervention of a professional mediator can offer a practical and cost-effective way to minimize the disruption of an organization or of a business. So we are saying that workplace mediation should be explored by HR professionals, by HR managers, so that the company does not spend resources wasting time in court and trying to settle on matters, paying damages. So we can go to the very last slide. That is me. My name is Julia Atieno Ogola. As I said, I'm an advocate, and my firm is Mushui Muruken Atieno Advocates LLP, MMA, Law LLP. You can reach out to me on the various emails provided. You can also reach out to me on the phone number. My firm deals with alternative dispute resolution mechanisms like mediation and arbitration. You can also come as a mediator and as advocates to help in whichever sessions or whichever disputes you would like us to have. And we also deal with employment matters. If you have such matters, you can also refer them to us, MMA Law LLP. And I also have a YouTube channel, Atieno Ogola the Lawyer. You can see it. We also try, personally, let me say, I try to educate people on their rights as citizens. I try to educate people what is expected of them according to the law, because legal knowledge is not freely, freely available to everyone. And so sometimes an individual may need someone to break it down in the most, in the most easy way to be able to understand what the law says. So thank you for your time. Thank you for logging in. And I hope as HR professionals, we are going to look at sustainable practices that will actually be able to promote the success of the organizations. Thank you.
Thank you so much, Julie. Thank you so much. Let me just stop sharing, because we have a myriad of questions for you here. There's so many. Let me start with the ones that, yeah, before I give my takeaway of the so much that I'm carrying home today. But let me just start with questions. We have around 40 minutes for you to answer these many questions that I'm seeing over here. So the first one goes to you, which is, can the court refer a matter to ADR process against the employee's wish, or is it voluntary?
Let me say it depends with the stipulations of an act. You see, when I was talking about the systemic review of employment and labor-related cases in Kenya, I was saying that there was that case which I mentioned where it said that if a statute expressly provides that a matter should be handled through ADR before going to court, the court will send you back to ADR even if you don't like it. You see, it is compliance through the law, because someone else could challenge, and we are saying procedural fairness is both on the side of for the employer and the employee. Okay, so if a statute, and judges rule according to the law, not according to maybe any perceived emotions or any other thing. So if the statute says, for example, I said the Labor Relations Act, that trade disputes should be first conciliated, then they go to court. I think then you've seen doctors, nurses, teachers, lecturers, everyone trying to mediate before it goes to court, right?
Yeah.
Yes, so if a statute expressly provides for that, the court will send it to mediation or arbitration, whether the employee or employer is smiling with that decision or not. Thank you.
Wow. And the next question from the same person is asking about, we have seen cases whereby people go for ADR, but it is abused and you don't get justice.
That's why I said there can be different outcomes for the ADR processes, okay? And that's why we are saying it's an alternative to litigation, okay? If it does not work, And you see, that's why I said mediation has to be voluntary. Okay, and just maybe even if it is imposed by you on by statute, if you go through that process and you're not able to reach an amicable solution, we have the courts. You have me here as an advocate. You just retain me. I go and give you my best representation, and we go back home smiling.
Wow. Thank you for that. And then we have another one that they're asking, how do we put in place effective and efficient ADR mechanisms in stagnant organizations?
Okay, in stagnant organizations, I think stagnant these days can be meant to mean anything, because we've seen Corona has really affected businesses. But one thing I've said, put it first in the employment contract, okay? You know, say that ADR mechanisms will be explored, you know, before dispute escalates to litigation. Put it in the human resource manuals, the policies, okay? That as an organization, our policy is to internally resolve something before it goes out to litigation. That's why, Jane, I think you've noticed there are some organizations you'll never hear the names mentioned in court.
Sure.
Why?
Sure.
They have good internal dispute resolution processes that are working. So if you also need to be helped to develop that, I'm also here. I'm an advocate. I'm a mediator. I can help in developing or in training the organization to be able to understand the various dispute resolution mechanisms that will work. Because you see, for me, I'm saying mediation. You see, but there's arbitration, okay? Mm-hmm. So you should first start with the first thing at the employment contract. Mm-hmm. Then look at your policies. The policies that you develop, are they aimed at the sustainability of the organizations? Yes, the organization might be stagnant, but that is not related to really HR. That is financial, right, Jen?
Yes. And I just like what you're calling us to do, because what you're calling us for is a shift in mindset. Must we always say we want to go through the disciplinary process? Or should we now start thinking about an alternative? Before we even go through this that is so adversarial, what else can we do that is different? That is what I hear Julie calling us as HR people to actually take going forward. So, and I am happy that you have offered to help those who are willing to put this in place. And I like the place that you're saying we start by putting just this particular possibility in our contracts and in the HR policies. So thank you for that. If you allow me, I'll go to the next question. And someone is asking, the fact that this is a confidential meeting, do we need to take minutes as a record?
Yes, you have to take minutes, and the person who usually takes the minutes is the mediator, okay? And you see, because the mediator once has helped both the conflicting parties reach to an agreeable solution, they decide a binding mediation resolution, which they have adopted, okay? And that resolution is shared to all the parties who are involved in the mediation, so that tomorrow, if any of the parties decide to go to court, we'll say, but we signed this agreement. We've already agreed. You know, why are you again taking the matter back to court? So most of the times in a mediation process, it is the mediator who's facilitating the process, taking down the minutes. And of course, it can be supplied to both or any of the parties, because again, you know, that's why we are saying in the courts, evidence is everything. So having evidence that indeed we went through this mediation process, we signed this agreement, can really shield you as a company or an organization if an employee decides to sue after mediation, after successful mediation.
Okay. And I think by that you have answered the next question, which was from Cecilia Maina, which was, is the mediation's final conclusion legally binding?
Yes, it is binding. I've told you even right now, we have court annex mediation for family disputes. Once the court has assigned a family a certain dispute, once the court has assigned the parties a certain mediator, once they reach an agreement, it is adopted to court. The same thing once even a mediator has helped two conflicting parties has reached an amicable solution, it is binding.
Okay. We have some questions that are just touching on legal provisions away from arbitration and mediation. I will save those ones for the last. Like one of them is, do we have to do a disciplinary hearing on probation terms? If you have terminated someone during probation, do we have to do a disciplinary hearing?
Let me say one thing, Jane. Fair hearing cannot be shied away from, because procedural fairness is one of the core importance of fair hearing. And let me say, if you look at our Bill of Rights, there is article, I think it's 49 or 50, actually it's 50, fair hearing principles. You see, whether an employee is in probation, whether he's just there for one day, you want to chase him away, just hear them out. I mean, it's also just basic common decency. You know, you're not acting like an arbitrary ruler. You know, we are long gone. I mean, okay, yes, we are still having some challenges here and there, but I think we are not, we should actually try to be decent human beings. So when someone has erred you, try and just hear their side out. I know, as I've said, it is not an easy process, but if you need a mediator, here I am. My firm offers mediation training. We'll be there to help you and help you solve your disputes. Thank you.
Thank you so much, Julie, for that. I'm just going to emphasize on that particular one because I've seen it in almost all the walls of HR this week. People asking about this guy who was fired from the Standard Group and why he was not given a hearing. And we had a lot of discourse, guys saying we didn't have to be heard because it's probation. Others saying he should have been heard. And it's such a big discussion. So I think we have heard it from Julie today that the decent thing to do is just hear the person out. They're still an employee. And Julie, a different question here from Marcus, and he says, let Julie comment on the current situation at LSK, where jobs are being advertised with incumbents still on the job, and the fact that this is being championed by non-HR practitioners. Can they use ADR?
Yes, as I've said, all matters can be solved through mediation or arbitration, okay? And we've seen there are different types of alternative dispute resolution mechanisms. We've seen there's mediation, arbitration, conciliation. Now, as regards the dispute at LSK, kindly, Jen, as a member of LSK, I will not want my practicing certificate to...
Excuse you. It's okay. Don't even say much. That's
yes.
Okay. Yeah, we can move to the next question. And someone is asking the difference between mediation and arbitration. Yes.
So let me just briefly talk about that. You see, in arbitration, actually, it's like a formal court procedure, but the difference is that you actually don't go to court. You see, you just call an independent arbiter, who is an arbitrator, actually, and the decision is reached by the arbitrator. In mediation, it is the parties who reach the final decision. In arbitration, I can just even go forth to explain to you that you even present documents of evidence. Okay?
Okay.
It is sort of an informal court process. Okay? So the arbitrator is the one who will make the decision for the two conflicting parties, because sometimes the major reason people would opt for arbitration is because maybe you're in a situation where both of you are not able to reach an amicable solution through mediation. So you'd rather someone help you reach that decision or make that decision for you. But again, you also don't want to go to court. You're getting?
Yeah, I get the difference.
Yeah.
And we have one here from Unfaith Beat, which says, what comes first, the disciplinary process or ADR?
Let me say it depends on the HR policy at your organization, okay? You can decide as an organization to adopt ADR before disciplinary processes. I've clearly stated when you're talking about mediation at the workplace that sometimes the disciplinary process can destroy the working relationship, or even a situation where you can use mediation is you can use it in place of a disciplinary process. Okay, so it is actually dependent on the HR policies of an organization, whether you decide to do ADR after disciplinary process, but most of the time it won't work because people are already aggrieved and people are already running to advocates like me to represent them in court. Okay, so the best way I would actually advise is ADR so that you're able to settle it. But of course, also as a HR manager or professional, you also weigh. Sometimes there are some instances where the disciplinary process would actually be inevitable because maybe the employee is not a first-time offender. Okay?
Okay. Okay.
Yeah.
And then we have another one here from Lino Dera, which says, can the same ADR be included in the service contracts that are issued to service providers in the organization?
Yes, indeed. We've said, I mean, even if you look at very large international, multinational companies, ADR is provided mostly now for such companies, it's arbitration. So dispute resolution can include and includes actually ADR and litigation. So even for service level contracts, you can actually put the first way is arbitration, especially where large sums are involved, of course, and you can't be able to make a decision. You can put that you go to arbitration, then litigation as a means of last resort.
Thank you very much. Like I said, HR people, it's a call for our mindsets to just shift a bit. Instead of always thinking disciplinary and then litigation, let us think, how else can we handle this? And I think why I'm enjoying this session is because we have always seen this in the family setup. I don't know how many people would have been divorced if this didn't exist in the informal way, where people just come and mediate. So another question for you, Julie, elaborate more on the class action waivers in employment agreements.
So what the class action waivers I was talking about, for example, we see in the Civil Procedure Act, you're allowed to bring a suit as a group of people. I think then you've seen, for example, let me not talk about maybe employment, but or rather, yes, I think there was this issue for Kenya Railways, where there was the employees were suing because of pensions. I don't know if you heard about that case. So you see, they were suing as a group of people, okay? So the waiver you can put in the employment contract is that if a dispute arises, you sue as an individual.
Wow.
So that is the major, and let me say, because you see, if you leave it open, and I know maybe, of course, people can be malicious. So if I know you are not a good employer, I give something small to all your employees, and maybe they are 50, then they are suing the whole company. What will be the fate of the company? Okay.
Wow. Okay. That's new for me. Can you talk about the composition of members in the ADR mechanism?
Composition of members, I really don't understand what maybe the person was meaning by composition of members, but in an ADR dispute resolution process, there are the parties and the mediator. And sometimes the parties might want their legal representatives to be present. So mostly it is the parties who are in conflict and the mediator present, and also the legal representatives of the various parties.
So it will be the same way you go to court. Maybe HR is representing the employer here.
No, okay, let me say, for the mediation, it is not, let me say, mandatory to have your legal representative, because you see, if you bring in these advocates like me, we will also want to have a legal aspect to the mediation. But here we are just trying to resolve the dispute without bringing in other complex procedures that are involving legal matters. Okay, so we're just trying to find out what are the issues. You see, if you bring in your lawyer to that mediation process, most likely it will fail, because the lawyer will always tell you, but the law says this, but the law says this, But if, for example, especially in children matters, yes, the parties are divorcing, but we just say we are here to determine the best interests of the child, which are of paramount consideration in any matter involving children. So we leave out our lawyers and say these are our children and this is what we should do. Even as a HR professional, if you bring in your company advocate or the advocate retained, of course they will tell you all things you want to hear, how you can defend your suit, how you can do everything. You know, if I also am acting for the employee, I will also add to them the salt to the injury and tell them, these are your rights, this is what you should do. But if the warring parties or the conflicting parties come independently, an amicable solution is always the result of the mediation.
Wow. So just to understand what the person was trying to ask, because I'm thinking maybe as HR, you still have to go back to the MD. So who should sit in this? Someone who is able to make the decision and just own them, or how exactly should we go about this?
Oh, I think now I understand from now what you've just said, the members. So I think, again, Jen, this would be actually based on the HR manual or policies of an organization, you know, because you can provide that actually at the mediation process maybe, which is carried out internally or in which a professional mediator is helping the organization to mediate. Maybe a senior, let me say, occupant of an office has to be present, okay? Because again, you see, the importance of that will help in, say, in reducing maybe someone saying this one said this at mediation, this one said this was not the outcome. So maybe having a senior management office holder at the mediation will actually help in, like you see, like when you say a witness, someone to witness that indeed this process happened and this was the result. So I think it's majorly on the HR policy or practices of a certain organization.
Thank you. And I think it will also depend on your wisdom at that point of choosing who sits in the committee. Because again, you don't want someone doing over consultation. When in the middle, they have to go check and then come back and all that. So it depends with what you're dealing with. And then we have another one here. Do you think ADR is going to weaken the role of trade unions?
ADR cannot weaken the role of trade unions. You know, let me say one thing, Jane. It's the same way you would ask, has ADR contributed or has it weakened the institution of marriage? Could we now make such a conclusion? You know, one thing people should understand that litigation is also a dispute resolution mechanism. But we are saying we are providing alternatives. It cannot weaken trade unions because most of the times, or okay, let me say, I understand, and I do not want to maybe belabor on that point, but I understand sometimes the nature of the grievances that are brought by trade unions. You know, sometimes people have gone without pay for a while, you know, be it the doctors, the lecturers, the nurses, of course, and everyone should earn an income, which is considerably true, okay? But we're just saying, try other means. And we've seen, I mean, doctors are good examples. You know, when the mediation failed, they quickly went to court. Their leader was held in prison, but they still remained true to the cause. You see, there's no way now KMPDU has been weakened. Can we conclude now KMPDU has been weakened because it tried mediation or reconciliation and failed, and then it went to litigation? Can we then conclude that, Jen?
I think you're right, because also when they go to the streets, when the union goes to the streets, by the time they're coming back, it's actually just negotiation, and I would imagine out of mediation happening at that table for them to resolve that conflict out of court. So I think they should embrace this. They should embrace this. Yeah. And the other question, when we're showing the legal framework, someone says, is the Fair Administrative Act 2015 not part of the legal framework for labor cases?
Let me say the reason why I didn't include it, it's because Fair Administrative Action Act actually mostly applies to, or let me say, people in the public sector. You see, fair administrative action should be carried out by a holder of a public office. Yes, it can be part of the legal framework, but indeed, mostly it applies to HR managers in the public sector. I can say for sure, if you're a holder of a public office, you should ensure that you are adhere to strict procedural timelines and also provisions, you know, because again, you're held in a higher, let me say, higher expectation by the public that you're supposed to, you know, conduct yourself in a manner that is, that shows that you have the ethics. You see, that's why you have the Leadership and Integrity Act. Okay, so as a holder of a public office and if you're a HR professional who holds a public office, then indeed the Fair Administrative Action Act would apply to you. And if you do not conduct let me say, if you don't conduct yourself in a way that is termed as administratively fair, then you will meet us in court.
I like that.
Yes.
We have another one here. Does fair hearing also apply to cases of redundancies?
Yes. You know, sorry, Jane, I have belabored this, that fair hearing is a right. It is a right. It is not, you know, I don't know if really sometimes we understand what a right is. It's inherent. You should give me fair hearing. It is in Article 50 of the Constitution of Kenya 2010. When something is a right, it is, I don't know how to belabor this more, but fair hearing is important in all types of disputes, be it redundancy, be it, you know, because Grace, that's what I'm saying. If you skip that process, especially if you're a holder of public office, people will quickly rush to court. You see?
Okay.
So I would advise that we adhere to fair hearing principles, you know, call the employee, try to understand, and if we are not able to reach an amicable solution, then of course we are here as advocates at MMA Law, LLP, to assist you in your court process.
Super duper. Thank you very much. And since you are saying you don't know how to deliver, let me just do it again. That for any separation, please, for any disciplinary case, have a valid offense and a fair hearing. It's the most decent thing to do. We should not have people waking up to emails of them being fired because of whatever without a fair hearing. It's a minimum, it's a right, as Julie says it here. Then we have another question here, which goes, someone had said their mic was off. Okay, let me just have the next one. Yes, we shall email the recording to all of you. And it's also in YouTube. If you just go to the YouTube of IHRM, it will forever be there. So if you're worried about the recording, just go to the YouTube and you'll find it there. Someone says, can counseling programs within the organization be an option for mediation other than having an external arbiter?
Yes, indeed. You see, counseling to some extent also helps in restoring relationships and in handling disputes. But again, you know, we should understand the role of counseling. Does it really go to the root of the issue? Does it bring the warring parties, you know, to sit down and air out their issues? Sometimes I see counseling, of course, maybe, unless maybe the organization will term it as group counseling, or maybe the parties being, excuse me, the parties who are not in good terms actually brought together and counseled. But I would advise mediation because it brings out the real issues. You know, I feel counseling most of the time is to help you become a better person. This is my opinion, but I think mediation will bring out the real issues, you know, and try to solve them. I think counseling is good. I can advise group counseling, but where also as a HR manager, you should assess, is this a matter that really requires counseling, or is it a matter that needs to be mediated? Thank you.
Thank you, Julie. And maybe just to add on that, counseling is very different from mediation, very different from coaching, very different from men. They all have their space. And I think, like Julie is saying, it's very important to know when do we need counseling, when is it for mediation, when do we need something, a different set of medicine for us to be able to handle ABCD. So thank you very much, Julian. We have another question here, or a concern, someone saying, mediation doesn't seem like a fair way to handle sexual harassment complaints.
Yes, allow me to comment on that, Jane. I said that indeed, in some instances, actually, sexual harassment complaints actually should not be handled through mediation, especially when someone has been personally violated, or where there's actually a threat to the person's life or imminent danger. Then I have said, and I've repeated, that it should not be explored, because of course, if death results or more harm results, then as the HR professional maybe who had recommended that, let me say, that process, it will be will be held liable. That's what I was saying. Of course, you'll have to exercise wisdom and discretion. Okay. Yes, you can provide that in the HR policy or manual, that sexual harassment can be handled through mediation, and if it's not settled, of course, to litigation, or the aggrieved party is free to decide which dispute resolution process is best for him or her. Yes.
Thank you very much. And Dr. Peter Kitonyo says, the success of mediation is dependent on the willingness and openness of the parties involved to reach a solution. I cannot agree more. So I think that also adds the weight on sexual harassment, because in sexual harassment, the aggrieved party may feel that they don't want to sit and talk. So as long as that's not something that they're willing to take, then you can't use it. And thank you, Julie, for that insight. Someone says, at what stage should the HR manager engage a mediator? As it is, the path to justice is clearly spelled out in the labor laws and the CBAs.
Yeah, at what stage? I've said, at the stage which the dispute has arisen. Do you want it to escalate so that you pay us a lot of money, you know, as advocates? So for me, I'd say, and you see, Jane, I've said there are some certain statutes that provide for ADR before going to court. Okay, so you can actually try to evaluate whether this matter, at its point that it has reached, should go to ADR or should go to litigation. But as I've said, as soon as we are saying green HR, we are saying sustainable human resource management practices, as soon as a matter or has arisen, the most, let me say, the better way to go about it is to try and resolve it. If mediation fails, is when we can use litigation.
Okay. Thank you very much. And someone is worried about their job, and they say, for the HR manager who is from time to time inviting over a mediator to the workplace, will he or she be relevant anymore to the employer?
Yes, you see, Jen, I've said something that as a HR manager, you cannot mediate all cases because you're not seen as independent and neutral. And the organization or the, let me say, the overall boss should be able to understand this. And I think that's why I'm saying mediation is still, of course, it is popular, but some people don't understand that the party who's mediating has to be neutral. You see, as an HR manager, you can't be neutral. You're employed there to do your work as HR, you see. So you're not there to smile with employees all the time, but you need to give them the decent process of hearing their grievances. So if you know that indeed you're not going to be impartial, you can advise, you know, that we need a professional mediator like me, so that the matter does not escalate to court. Because, you can just tell your employer, then, these are the costs will incur in litigation, and these are the costs will incur in mediation. You see? Mm-hmm. So again, another way I've seen some organizations do it, the way you can retain a law firm for matters, you can also retain a mediator, so that you tell this mediator, whenever disputes arise, you should always be on call. You come and help us solve this dispute. You won't lose your relevance. I don't think HR is all about dispute solving. Am I right, Jane?
You are very right. Yeah, our work is not limited to solving conflict. And I think so it's a value addition, because there are things that you can also mediate, because maybe there are things that you can afford to be impartial, even at the workplace. And then there are those that you have to escalate to an external person. So I think it's just that balance of knowing what you can handle internally as the HR person, if you have the skill, and what you have to escalate because you don't have the independence in the matter. So
yes. Yes.
Thank you very much. Someone says, interesting question. The HR manager should undergo mediation training. That's what they've been told. In my view, HR professionals should embrace mediation as an additional skill to remain competitive in the profession. She can thereafter extend the mediation skills to the society at large. Someone says a good skill to have. Someone says it is true. It's going to make HR management should be agile, and solving conflict is not a reserve. Indeed, the perception that HR solves all problems is mother of poor perception of HR.
Yes.
Yeah, so we have that coming from someone that doesn't have a name, all panelists. Then we have great session. What is the difference between out-of-court settlement and mediation?
So let me try and break it down. Sometimes parties can go to court, but in the middle of the court process, they feel that they can actually settle this matter out of court. Okay, so they will reach an out-of-court settlement through the already hired advocates. Then the advocates bring the agreement to court to be adopted. Okay, but also mediation is a form of an out-of-court settlement. It is in itself, in its literal meaning, out of court. We have not gone to court. Okay, so anything that is settled out of court, results to an out-of-court settlement, of course. But now the agreements will be different. For example, we have the mediation agreement, the arbitration agreement that is resulting from either processes. So alternative dispute resolution mechanisms are an alternative to litigation which involves the court. And we've seen the Constitution even provides for traditional dispute resolution mechanisms, which I stated at the beginning, where we have the Council of Elders or elderly people calling out the grieving parties to sit and talk.
Thank you very much. The person who is asking for the YouTube channel, I've just shared on the chat down there. You can copy it. You can also make it one of your favorite pages to visit. Someone is saying at this rate, HR better get a mediation cost training to be giving it when needed. And then we have someone saying, if an employee is terminated, he may not appreciate the use of ADR since he is already out of job, or rather not bound anymore by the policy clause of ADR. Such an employee may have to go to court. What do you have to say to that, Julie?
You see, that's why, Jane, I said, before you terminate, use mediation. Of course, yes, maybe it is inevitable that you have to terminate, but bring this person and sit them down with an independent, impartial person. You're getting what I'm saying, Jane?
Yeah, but I have a follow-up question. This person has stolen or has done something that you really have to just fire them. So either way, you have to fire them, and you have done the arbitration, but either way, you have to let them go. So you have followed due process, but they have gone to court. And this person is asking, so you have terminated them, they're not out of job, and they're not bound by your policies, even if your contract says, let's do ADR, and they go to court. What happens?
So of course, we'll just employ the court procedures. You see, now that's what happens. Because you see, that's why I'm saying, Jane,
Mm-hmm.
Yes, indeed, someone may have done an offense that it requires termination.
Mm-hmm.
The first thing to do, try and mediate it. And even when you mediate it, if indeed, you should be, and you have the evidence that you stole, and that's why we are terminating you. End of story. Okay? And you've also given them the fair hearing in Section 41 of the Employment Act. Okay? So if they decide to go to court, you already have done your due part, so that even the advocate on record for the company, will be able to ascertain that indeed, as a company, you followed the due procedure for termination. And indeed, you have evidence of the issues that the employee had actually committed that warrants the termination. And you clearly communicated why you are terminating them through mediation. I do not think a sane judge will try to bring you to, to the worst situations when you have done your due process as an organization.
Thank you very much. I think I get what you're saying. That internally, the purpose of hearing is actually mediation. It's still within the disciplinary process, and it is part of the disciplinary process. So you have done the following. Instead of just firing, you call them for a hearing session, which I think is what Julie is saying. Internally, you have a hearing, you have a mediation process. You want to sit there as HR, as the independent party, listening to what the employee that has committed the crime needs to be heard, representing the employer, and maybe somebody is also there, maybe the line manager. So if we skip that process, then we have skipped mediation. And then there are times that can't happen internally because you're already too much involved. So on a normal day, before firing someone, just that hearing is part of a mini mediation process. If I hear you, Julie.
Yes.
We're coming to the end of our session. It's supposed to end at 4:30, but I still have some more questions. I don't know, you give us 5 more minutes, or should we bring it to an end? You have more time. We have some 5 more to close. Julie?
Yeah, I have time. Sure.
Okay. So here we have what comes first. So I think that has been what comes first, the disciplinary process or the ADR. I think you have answered that. Someone said it's very helpful. Thanking you for the session.
Thank you.
Miss Julie, can you elaborate more on what would be the plight of parties who subject themselves to ADR mechanism, reach an amicable agreement, which is reduced to a binding agreement, but thereafter, either one or both of them breach the same agreement? What is the plight of parties?
What will be the
plight?
The plight. Of course, you see, Jen, when you breach an agreement, you can now go to court and call me as your advocate. There was a binding agreement that was reached upon mediation. And I think, Jen, you've seen this it's the same thing if you actually defy a court order. You're actually subjected to the court again. Okay? So that's why I'm saying that it is important that we try to abide by the mediation agreement. And if a party breaches it, of course, there's always recourse. There's nothing that cannot be compensated for. Yes.
Okay. So we have a case here, which I don't know whether it's enough time for you to respond, but someone says, an employee is issued with a show cause letter. There's a delay to hold a hearing. However, a hearing is scheduled and communicated to an employee on email and telephone, but fails to turn up on the scheduled date and time. Instead, through an advocate on the material date and scheduled time, he brings a demand letter that a disciplinary hearing has been delayed. Are we bad to proceed with the disciplinary hearing? I lost the case. I think you can proceed from where I'd reached. Are we bad from proceeding with the hearing, with the disciplinary process at that point? Did you hear me?
You see, Jane, that's why I say that it is important to have good communication with your employees. There are sometimes delay can happen because of unforeseen events, okay? And then, of course, now when the date has finally been scheduled, the employee has come with his advocate like me and issued you as the HR or the company a demand letter. Okay. So one thing that will be evident, especially if there's that evidence of email or calls, you see, it is good to see that, or even if the matter proceeds to court, it will be very evident that the organization wanted to ensure that they comply to the fair hearing principles. And at that time, you see, you cannot force an employee who has already hired an advocate, to a fair hearing session. Okay, so unless maybe, let me say, the demands of the employee, which are stated in the demand letter, can be, let me say, mediated upon, maybe through now the employee's advocate. You see, because a demand letter, the advocate says, failure to respond to this or failure to meet the demand within 14 days, a suit will be instituted. So within those 14 days, as the HR professional, are you able to sit down with the advocate of the employee and try to negotiate, even if yes, it's paying on in a staggered way, or paying compensation in a staggered way? You can always sit down with the advocate of the employee and try to now act according to the demand letter. Because when you fail as an organization to act on the demand letter, as an advocate, I act on the instructions of my client, and I will institute a a civil suit, and you'll be served to enter appearance.
Okay. Thank you very much for that, Julie. Maybe just to add, sometimes we have timelines in the disciplinary procedure. Like you said, you'll have a hearing in 5 days. We'll have ABCD in this particular time. As HR people, sometimes also send to indefinite period of not communicating. And I think that's not fair. So I don't know that that's the case here. So maybe just a call for us to adhere to that particular process and to communicate when we are going to deviate. If you know it's not going to be happening in 5 days, then communicate to that particular employee. Then you don't have to have such surprises. All the best in sorting that. We have HR is a connector between the organization and the employee conflict. And the employee conflict arises due to one party feeling at loss. This makes conflict resolution a core function. Point informative, someone says thank you for the good session. Someone says thank you. Thank you again from Ezekiel Makori. A lot of thank yous.
Thank you.
Yeah, on termination, an employer terminated on malice. After a week, he realized the person terminated was the best worker. There was no reason for terminating. Does ADR really work on this one, or should one simply go to the court? The employer sent some forms to the employer to sign, binding her not to go to court. Was that fair, really? There was no reason for termination. You can respond.
Okay, you see, that's why I say it's important also as HR professionals to actually advise your bosses, because, or even to be advised on the best course of action. I mean, you cannot just fire someone without any reason, then again you send them, a contract not to go to court. You see, that is infringing on someone's right. And actually, the employee will sue you first for not giving them a fair hearing. Then you can now talk about not going to court while we are in court. Okay.
Okay. Thank you very much. But just also tells you again, you must have a valid offense before terminating anybody, and you must have the fair process. So the two are tied together like this, and we should stop working with one. Yes, nimechapa manager coffee. That is an offense. Now let's have the process. Give me a hearing. Let's mediate. So the two must always be together. Then we have one that is off cuff from Abdikarim Ayugi, who is saying, thank you very much, the speaker, Miss Julie, to me, Jane, and to the executive director, Ms. Ahmed Quresh Abdullahi, for this session, not forgetting the attendees. And he says, through this networking, he wants to let all of you know that he's looking for a job as a HR assistant. I'll paste his number down there just in case you guys can help him. And then someone asked, did we get points? Yes, we get some points, I guess. Look at the flyer. A lot of thank yous, a lot of thank yous. How can one participate in your programs? I guess that is for you, Julie.
Okay, maybe someone could, I think they have not stipulated the programs they'll want to participate in, but I can just type my I don't know if I'm able to.
You can even tell me and I'll just type it your number, or I can take it from the PowerPoint.
Yeah, you can take it for the PowerPoint. Someone can just actually call me, or I prefer calls. Sometimes emails we have a lot of work as advocates. Sometimes I might miss the email, but I think a call will be better. So I think you can just type my number.
There we go.
Thank you, Jane.
So you can have the email, you can contact. If the question was for IHRM, again, you can always call IHRM. We have Milk Wow here, we have the ED here, and I'm sure they'll be able to respond to a specific question on what exactly you'd like, what program you'd like to attend to. Can you have mediation with an employee who is having mental issues? I guess that is counseling, but back to you, Julie. And
you see
that.
You see, Grace, that's why when in court, when the court realizes that the person who's accused or the person who's the defendant is actually having mental issues, they actually halt the process, or rather give a stay, pending the person who actually is having mental issues to be attended to. So, you cannot actually mediate with someone who's not in their sane mind, because they will tell you all sorts of things and you will agree, then they'll come and say again you didn't actually agree. So I think in that situation, the person should seek first, not even counseling, but medical help, Then when they're in their right state of mind, a mediation can occur.
Okay, thank you very much. And I think that brings us to the end of the session today. Just to recap what we have learned from Julie. One, it's a shift in mind that mediation is an option that we should first embrace before you even rush to the courts. Two, it is the newest kid in the block when it comes to solving conflict. It's a skill that we must have. And when you know that you cannot remain independent, it is okay to seek help for someone else to come and be able to stand in and be the mediator for that particular event. And then 2 or 3 or 4, I don't know, so many points here. For you to terminate anybody, there must always be that valid offense, and there must always be that particular hearing, which is what you're calling a mini mediation in a disciplinary process. And then another takeaway, we can actually anchor this in the contract. The clause on arbitration and mediation, in case there is a dispute, in case there is conflict, we can actually have that in the contract as our first method of trying to resolve it before we choose to go to court. We can put that in our policies, and of course, you have to keep educating them to know that that's an option that they have before rushing to court. Maybe I'll doubt, if Kuresha is still here, I can give it back to you to just say, give a vote of thank you, and and say a word to Julie.
Thank you so much, Advocate Julie Ogola. That was very insightful, lots of learning. I think one thing that as HRs and the role that we've just gotten for ourselves is to ensure that our organizations, companies are practicing best use of resources, and we're giving the right advice. And we've just been given 2.5 hours each on how we can use ADR. And I have a lot to take away from here, new stuff to learn. I'm hoping the same for all of you. Just as a follow-up, we have a workplace mediation coming up 4th of July. You can go to our website, and it's 2 half days. This conversation can go, and it will be richer when we have 2 days online training on the same. Ours is just to appreciate you for your time and let the learning continue. Asanteni sana for your time. Really appreciate. For those of you who asked if we will share the presentation, Jen has already shared that we were live on YouTube, and that remains. You can use that as a reference, and we'll also be sharing the presentations with you for those who have registered to the emails you've used to register for this session. Thank you so much, and have a good day, everyone.
Thank you. And I'm now
Thank
going
you,
to end the
Jen, also
meeting.
for the amazing moderation.
Thank you,
Asante
Koresha.
sana. Yeah.
Asante. Okay. I can end the meeting unless if guys want to stay at work and there's someone to do that.
I can say one more thing, Jane, that I am reachable. I think I have provided my contacts, and we are also mediators, we are advocates. So everyone should feel free to reach out to us if they have a contract, if they need internal mediators, if they need training internally as a corporate, we are available at mmallawllp.com, and our contacts are also there at the website. If you just Google mmallawllp.com, you will just find us. Thank you.
Thank you so much, Julie, for your time. I guess we can now end the meeting.
Yes, we can end the meeting now. Asanteni sana. Thank you for everyone who joined us from Turkana to Mandera. We appreciate you for your time and not forgetting all the other towns. Until next time.